I want to throw out a word that we have heard a lot about so far during this conference. Rigged. It's a loaded word, often uttered by a former president of the United States. But here and in many states across the country, it is being used by Democrats and Republicans to describe how the legislative maps are drawn. If you haven't seen it, I would commend an article published just a few days ago by a former colleague now at Marquette's Law School. In it, he wrote, "The outcome of these legislative elections is largely predetermined. It is overwhelmingly a function of the map, not the candidates or the campaign or the election climate." Indeed, a powerful statement. Fortunately, we have three experts here today to help us try to make sense of it all. Michael Lee is a senior counsel for the Brennan Center's Democracy Program. Wendy Underhill, who you met earlier, is the National Conference of State Legislators Director of Elections and Redistricting. And to her left is Jeff Mandel, a co-founder of Law Forward, who is in the middle of a lawsuit on this very subject. So they've worked out the lineup amongst them, and Wendy has drawn the first the first straw, so I will turn it over to Wendy.
All right, let's see if I can. Oh, there we are. We're already there. Okay, so you know who we are and what we do. Put together some very simple points for you. I am laying the groundwork. I am building the foundation, and then we have two legal experts who are going to tell you the part that you're probably more interested in, which is why are people fighting about this. But bear with me. You can't have your dessert until you get your vegetables first. So I want to talk about the census for just a minute on my first slide. And of course, you know that the census matters for apportionment, how many seats in Congress each state gets. But I want to talk for just a minute about the census in a different way, which is that it's not as boring as you think. You may think, like with water, you turn on the tab and out comes water, and you think you go to the census and out comes data. Well, there's a lot of stuff behind the scenes there that can be pretty interesting. And I know Hansi Lowang from NPR follows this very closely. I hang on by my fingernails to this. If anybody wants to talk to me about census stuff after the fact, I am able to do that and interested in doing that for several hours, so be prepared. Some questions that will be coming up are about the system that they've chosen to protect the confidentiality of their responses, and what does that do to the data quality. Another is how will people who are incarcerated be counted? Will they be counted where they came from or at the prison? That's a data question that they might answer. And the race categories. So those are just three things. So I just want to pique your interest on the census, if that's possible. How many of you feel that I have piqued your interest on the census? Oh my gosh. Okay, well, I love this crowd. Can I come next year too? Okay, so in case there's any doubt in your mind, it is the states that do redistricting. This is true for congressional as well as for legislative maps. Redistricting does take place at the county level and also at local level. Depends on how districts are established or if there are districts or if people run at large. Just want you to know that states feel privileged to have this responsibility. Now, there is a caveat that if Congress ever were no longer in the place where we see it now, they could put some guardrails around it, but I think that that has to go through a lot of political things before any change would take place at the federal level. Okay, the baseline for redistricting, I hope this is not a surprise for anybody here, is to have districts that are of equal population. You can imagine in some other universe where we do not live that you could have equal geography. That's not what's true for us, and I don't know if it's really true for anybody. Used to be, though, that redistricting was pretty much not done, and that the districts were established based on, let's say, county lines. And you know that in any given state, one county could be really big and have very few people living in it, another county could be very small. And so that was not fair. A whole series of cases in the 1960s established that it wasn't okay to let the rural parts of America have more representation at the state capitals or in DC. So that's what this is all about. So we went from where there used to be 10 times or far more than that people in one district than another to where ostensibly we have the exact same number of people in each district. Now, if you take fuzzy numbers and you add them, you don't get to a precise place with a certain number of people. You get a fuzzy answer, but that's different, and maybe you two will talk about the law on that. I think that's possible that there could be some change on that coming up. I'm not sure. Okay, then the next thing is race matters a whole lot. This is the non-lawyer representation of what's the status of the law here in the United States. Both of you get an opportunity to correct me on this. We have both the VRA, which says we must take into account race because we must give minority populations the capacity to elect the candidate of their choice. And we have the Equal Protection Clause of the 14th Amendment, which says everything should be equal. And when those two things get together, it means that the Supreme Court is busy every decade, in fact, almost every year of every decade. So this is a huge piece of what gets argued about and has been true for 40 years or more. Then I also wanted you to know that in each state, they do redistricting a little bit differently. Each state gets to decide what's the criteria that they're going to use, and some have a whole list, and some really are kind of silent, and then you'd only have that one person, one vote, and the question of race at the top that would be true for all the states. But I just want to call to your attention that something called communities of interest exists in the world, and many states say we want to acknowledge communities of interest, but how we measure that is very unclear. And in fact, unclear could be the one word if you take away from what I've got to say. Unclear is probably the best descriptor for everything that's going on. And I had thought going into this decade that communities of interest would be a big deal, and I don't believe that's actually been true when you went to court. So we might hear a little bit more about that as well. But at any rate, the rules are different. So if you say, well, that's how they do it in Minnesota, it doesn't much matter when you get to Wisconsin or elsewhere. Courts are always busy, and attorneys are always busy doing redistricting. It is, I'd say, 9 years out of every decade, people can be making a living on this, or at least some folks can. And there are many things that can be argued about. Everything I've mentioned so far, whether you've been in compliance with your own state's constitution and statutes, that's a good thing to argue about. And which brings me to, there's, of course, state courts and there's federal courts. They have different trajectories, and I thought that most of the arguments this decade were going to be in state court because of something that happened last time. I'm not sure that that's really been borne out since we've seen the Supreme Court pretty busy as well. But just know that you have experts here to talk to you about what the courts are doing or could be doing. And then I wanted to just mention the data a little bit. We've talked about the census. And obviously, census data is the core. It's at the base of redistricting. But redistrictors also bring in all kinds of other data to supplement that. Some of that is election returns, so you know whether area is more Democratic leaning or Republican leaning. We can argue about whether that's a good idea to use that data or not, and there is a handful, 4 or 5 states that prohibit the use of that kind of information. So it's not strictly essential. But I think a lot of states are also looking at demographic data that they might get from an outside vendor outside of the Census Bureau. So all of this data gets put into a big pot and stirred, and then who's got access to it? Well, in some places, only the majority party has access to it. In other places, the data itself is shared with both parties or with the whole state. And right now, one thing that's definitely different from 10 years ago is the capacity for each and every one of you to draw your own districts. Now, I think what's happened when these programs that have the data behind the scenes got put into practice is that a lot of people went in, and after they did the first 5 minutes, they said, oh, this is boring, and they stopped. But you might find it interesting, and in fact, a lot of people do, and if you like playing online games, this might be something worth doing. But my point is that data and the access to it is pretty different than it was 10 years ago. Let's just skip right past that. If you want to be active as the public, I've just told you how you can do it. And here too, I think in the last decade, there was more effort than ever before on the parts of, let's say, the League of Women Voters to encourage people to take a role in redistricting. And if you think about get out the vote campaigns, well, there was the idea of get out the redistricting folks. Now, they're not really one and the same, and I'm not sure how well that translates, that concept, but I do know that there was more effort put into having public input this last year and more systems for it, some of which are pretty elaborate than in other places. So you could ask questions about that. And then who's drawing the maps? That matters a whole lot. And I've given you a capital because legislatures are in charge in almost all the states, well, 2/3 of the states. So it's important to remember that even though we hear a lot about reform, it is still primarily a legislative function. So just think about that. I don't want to discount reform efforts, and we certainly saw change this last year. Michigan and Colorado in the last decade had major changes. So did New York and Ohio, which weren't quite as successful perhaps as the first two I mentioned. Reforms are in every possible flavor. So are they all the same? Absolutely not. Are they equally successful? Absolutely not. But this is where a lot of the action is. And we see states lining up right now. We see advocates in states lining up right now to make change for the coming decade. So you should expect to see more of that. And I want to say that the Brennan Center has tons of resources on redistricting. We have tons of resources on redistricting. There's something called All About Redistricting, which is fabulous. And there's another one you may not have heard of called Redistricting Online. Do you guys know Redistricting Online? I think it's pretty darn great, but that's because I know the woman who built it. So feel free to talk to me about resources and people you could talk to, because I've got contacts on both sides. So that's what my story, just lining it up with some procedural stuff. You're on, Michael. I'm happy to take questions, but I think maybe we should wait.
Okay, I guess I will also stand up since Wendy started the tradition of standing up. I was not planning on that, but I will do so. So does this go to mine? Okay. Oh, so that's me. I'm at the Brennan Center for Justice, and I have my contact information at the back. But first I wanted to start with a little bit of a lay of the land because, Wendy talked about how we do redistricting once every 10 years. And in theory, in many states it's done and then they don't do it again for another 10 years. But in other states, you see a lot of litigation over maps because, this is America. We draw maps and then we fight about them in court. And oftentimes litigation takes sometimes as long as almost the entirety of the decade. In Texas last decade, the litigation didn't finally get resolved until almost 2018. So really, a very long and attenuated process. But this decade, I think we're seeing more litigation than in the past. Now, I'll talk a little bit about why, and I'm going to focus my comments on the battle for control of the U.S. House, although I'm also happy to talk about state legislatures in the various states if you're interested in it. But so one of the things I think is important to understand is that one of the reasons that everything seems so intense right now is that the House is really closely divided. We've had two elections that produced almost mirror image results, one in favor of Democrats, one in favor of Republicans. And that really is very much an anomaly. From 1954 all the way to 1994, Democrats controlled the House for a 40-year period. And throughout most of that period, as you can see, Republicans didn't even get, and this is the Republican share of seats, Republicans didn't even get 200 seats in the House. However, since the 1994 wave election, control of the House has flipped 6 times, and it seems likely to flip a 7th time, or a good chance of flipping a 7th time in 2024. And it's really tight, right? And so, how the maps are drawn has a big impact on who's going to come out on top. And a big reason for that is that despite the fact that the House is really close, you would think okay, it's going back and forth between the parties. You would think, okay, that's a really competitive environment. Well, it is sort of, but not really. That there aren't really that many competitive seats in the House. There are maybe 30, 35 seats that, depending on how you count it, are competitive. This is 2022. If you look at it by region, there were only 2 seats in the whole of the South, which is, by the way, the country's most populous region, that were decided by 4 points or less. And similarly, you see a little bit more competition elsewhere, but most of the the districts had a margin of more than 8 points, which really, some of them could have been competitive, but a lot of them weren't. In Texas, there are, out of the 38 congressional districts, 22 of them, I think, are seats that Donald Trump won by 15 or more points, so not at all competitive. And that's really in part, sometimes that's natural, but a lot of times it's because of the way that maps are drawn. Similarly, this is an early look at 2024 from Cook Political. About 24 seats are really, they rate as toss-ups, a few seats of the, on the other side for both parties, but really not a whole lot that is competitive. So every single seat that you can get through litigation matters. And that's why I think one of the reasons why you're seeing a lot of litigation. So where could maps change for 2024? And I will say that there are other cases in addition to the ones that I'm talking about, but they will not, where they are procedurally, they're not going to get judgments on the maps redrawn, but these are the states that could be in play. So 10 states, quite a few, and as I'll talk about, that's way more than we had at this point last decade. A number of states in the South, Alabama, Louisiana, Georgia. You could see additional black majority districts drawn as a result of Voting Rights Act litigation. Florida, you have an aggressive attempt to dismantle a black district that was not black majority, but was about 46% black. That has been challenged in court and state court, and is moving its way through state court. North Carolina, where you had a very fair map put in place as a result of litigation because the North Carolina Supreme Court found that it was a partisan gerrymander. The court came, however, the North Carolina court reversed course. Partisan gerrymandering cases potentially in Kentucky and Utah, which are considering whether you can bring those kind of claims in state court. New Mexico, the court has determined that you can. The only question is the map there a pro-democratic gerrymander? And then in New York, you had the legislature's map thrown out, a temporary map put in place. The question is whether the temporary map is for the whole of the decade or was just for the 2022 elections. And so a lot of flux in the air. I mentioned that there is more litigation than in the past. And I think there really are 4 reasons why. One is that you are seeing partisan gerrymandering claims now brought in state court. In 2019, the US Supreme Court said you can't bring these claims in federal court, but voters are turning increasingly to state court and finding a lot of luck. So far, only Kansas and North Carolina have said that you can't bring partisan gerrymandering claims in state court. Other courts have said you can. These are the pending cases where where there could be changes. You're also seeing more Voting Rights Act litigation in the South. It's a little unclear to me why people didn't bring these cases before. I suspect some of it is that people thought that before the districts had to be really, really black in order to allow black voters a chance to win. But now I think people are understanding that you could have districts that are, say, 51% black instead of almost 60% black, and that allows you to argue for additional black districts. But you're seeing more Voting Rights Act litigation in the South. Those would all be almost certainly Democratic districts. You did see a lot of aggressive line drawing, particularly by Republicans. Florida is a prime example, which I mentioned, because everybody really thought, like, okay, the House is up for grabs. And then, as I mentioned, you are having some redraws because of a shift in state courts. In North Carolina, voters initially won a partisan gerrymandering case, but then the North Carolina Supreme Court flipped control, and they are now going to redraw the maps in a few weeks. So a lot of flux, and we still don't know quite what the maps will look like in 2024. If all of these cases come out in the way that the parties bringing them want, it's probably a net Democratic advantage. But we will see how all of this goes, and whether there are any stays in these cases or the like. I'm going to talk a little bit, close just a little bit, talking about redistricting reform. Obviously there are a number of, Michigan adopted an independent commission last decade. It ended up drawing very fair maps. I've called them jump ball maps for a jump ball state. Similarly, California, Arizona, Colorado have what we consider independent commissions. There were less successful reforms elsewhere. But right now there are ongoing efforts in Ohio and Oregon to create a form of independent commission last decade, there were efforts heading into 2020 in Nebraska, Oklahoma, and Arkansas to put ballot initiatives on the ballot to create independent commissions. Those all got sidetracked by COVID. People couldn't canvass. There were a number of issues. And then I think two states that bear watching where there aren't efforts right now are Florida, where you could see a strengthening of reforms that voters adopted by adopting an independent commission. There's some challenges there, which we can talk about. And then Illinois, where Democrats did do a gerrymander. People have long tried to put a ballot initiative on the ballot in Illinois. The Illinois Supreme Court keeps rejecting it. But we will see whether, that's a state to watch. So, this is a story that will play out through the rest of the decade, in part because I think, you could certainly, for congressional redistricting, have reform at the federal level. You could have the Freedom to Vote Act would have required every state to use an independent commission. It's unclear that there will be a majority in Congress this decade to do that before the 2030 census. So really the effort is on the states, and it's, as I mentioned, it's mostly through ballot initiatives. In some cases, lawmakers may try to do reforms. They generally don't do a very good job of it, and sometimes they do a really bad job of it. And you'll see, Jeff is going to talk, I think, about Wisconsin. I did not put Wisconsin here because I don't consider what's going on in Wisconsin a true effort at reform. But and it's not congressional. It's not congressional, and I can turn it over to Jeff. Well, these would not just be congressional. Like these could potentially be state as well, and Ohio would be. So, but I.
Thanks. It's a pleasure to be here. I wish you all great success covering the State House. I was telling Kevin that in the late 90s, I found myself as a young journalist covering the Texas State House. And it was a very interesting time, and it eventually sent me to graduate school and then to law school. So I wish you all more success than that. My name is Jeff Mandel. I'm a lawyer here in Madison. And I am, like many of the people that you encounter in your own reporting and working, I'm a lawyer. I work for clients. I work at a law firm. I show up in courts. But I also, I would suggest to you that Wisconsin has been sort of ground zero for the fight over democracy in the United States over the last 15 years. And going into the 2020 elections, as we saw how bad things were for democracy in Wisconsin, particularly on the state level, we created an organization called Law Forward to use litigation to stand up for democracy in Wisconsin. And so I am, in addition to my private practice, I'm the board chair of Law Forward. And I want to talk briefly about a case that we are working on now to change the state legislative maps. Right? So Michael is talking primarily about congressional maps and how we decide who gets to go to Congress. This is slightly different. The census changes how many people each state or 7 states get to send to Congress each decade. But how many people are in your state legislature is a question of state law and state constitutions. And here too, as both Wendy and Michael have talked about, there's tremendous variation. So I don't know if there's anybody here from New Hampshire, right? But New Hampshire has a huge lower chamber in its state legislature, especially for a state that, generally speaking, has a tiny population. Here in Wisconsin, we have 99 members of our assembly and 33 members of our state senate. And even though over the last couple of decades, Wisconsin has been a bellwether state, with the exception of the Obama elections, Wisconsin is consistently a close state. Were it not for Palm Beach County, all of the craziness of 2000 would have been here. Wisconsin, the vote differential in Wisconsin was a couple of thousand votes in the whole state. We were one of the closest states in 2020, and I expect that it's going to be a close state again in 2024. Notwithstanding that, our legislature is extremely partisan gerrymandered. In 2018, the Democrats swept statewide offices in the state of Wisconsin, every statewide, governor, lieutenant governor, attorney general. 54% of all the ballots for the state legislature that were cast by Wisconsinites in 2018 were for Democrats. The Republicans controlled just shy of 2/3 of each house of the legislature. And it's all because of the maps that were put into place. So we had litigation in 2021 and 2022, as there was in many states. That's called impasse litigation, right? When the legislature and the governor can't agree on maps, you have to have new maps because of one person, one vote. It'd be a violation of federal law to have an election where different people's votes are weighted differently. And so before you have that first election after the census, you've got to fix the districts. When the political branches can't get along, we wind up in what's called impasse litigation. We go to the courts and we say, hey, fix it. And that happened here. As part of that litigation, we actually asked the Wisconsin Supreme Court to tell us whether the state constitution forbids partisan gerrymandering. And the Wisconsin Supreme Court at that point didn't really answer that question. So what you have here in the Clark case is our effort to get the Wisconsin Supreme Court to tell us whether partisan gerrymandering violates our state constitution. And as Michael said, in 2019, the United States Supreme Court expressly invited people. They said, we won't help you in federal court. This is not justiciable, which is a fancy lawyer way of saying, get out. We don't want to talk about this anymore. But they said, go to your state courts, bother them, ask about your state constitutions, because this isn't a federal issue. And so that's happening around the country, and this is the case where it's happening here in Wisconsin. We've got 19 plaintiffs from around the state, diverse in a number of ways. We sued the government, because that's who runs the elections. So we sued the Wisconsin Elections Commission. I believe you all got to meet Administrator Wolf yesterday. It's nothing personal. She's doing a very good job. But they're the ones who run the elections. And part of running the elections is saying to candidates, here are the district lines, and here's what the ballots are going to say. And we want those district lines to be different and those ballots to say something different. And the way we did this is that we filed straight in the Wisconsin Supreme Court. You don't see this very often at the federal level. But some states, and Wisconsin is among them, allow this, where you have an issue that is of such intense public importance and is such a novel question of law that you know the state Supreme Court at the end of the day is going to be the one to answer it. And so you can go and you can start. It's discretionary here in Wisconsin. So we go and we say to the state Supreme Court, please hear this. We filed this case in August, and we're still waiting for the court to tell us whether or not it's going to hear it. There's a whole bunch of fighting about recusal and impeachment. You all read the paper. You've probably heard some about this over the last couple of days, but that's what's going on. Okay. The maps we have here in Wisconsin are truly an extreme partisan gerrymander. It's not just the incongruity or the differential between the election numbers and the representation numbers in the legislature. It's also that if you go back and you look at every state legislative map, right? So you got 50 states over decades, going back to the one-person, one-vote revolution in 1964. And in many of those decades, as Michael talked about, you're going to have multiple maps for one state because there was litigation, there were changes. If you go back and you look at all of those maps and you were to chart them, of which ones most consistently would give you a proportional representation to what you get in the votes, and which ones most consistently skew in one direction, partisan-wise, Wisconsin's map from 2011 to 2021 comes in 4th place in all of that history. And I would suggest to you that what the legislature and the court did last year actually made it worse. So our belief is that that extreme partisan gerrymander violates our state constitution in 3 ways. First, it retaliates against voters, specifically because of their viewpoints. And that violates every individual's right to free speech under the Wisconsin Constitution and every individual's right to petition an assembly under the Constitution. It treats some voters worse than others simply by virtue of where they live. That's a violation of the equal protection guarantee in Wisconsin's Constitution. And third, the Wisconsin Constitution, and not all state constitutions have this, has this specific clause that guarantees that we will maintain a free government. And we will do so by, gosh, I'm a lawyer, I'm not supposed to talk without the text in front of me, by frequent recourse to first principles of temperance, moderation, frugality, and democracy. something along those lines. I don't know exactly what that means, right? That's very sort of archaic language, and no court in Wisconsin's ever told us what it means. But what we have, we would submit, is not a free government. There are two other problems and claims that we've brought in this lawsuit. One is that the maps, right? So I said there was an impasse. The legislature's job, as Wendy talked about, is to adopt new maps. So the legislature, it legislated. It passed a bill and said, here are the maps. Well, the governor vetoed that bill. That's how we wound up in court. But when it was time for the court to choose maps, it chose the ones the legislature had passed to start with. I'm not sure that that's right. I mean, think back to Schoolhouse Rock and the separation of powers, right? And 3 equal branches of government. Why does the court get to say to the governor, we don't care about your veto? We're going to make that law anyway. I'm not sure that the court has that power. So we think it's a violation of the separation of powers and a violation of the governor's rights. The court can draw its own maps in certain circumstances, but it can't just sort of pick and choose between the winners and losers in the legislative process. The second problem, and there was mention of this in both Wendy and Michael's presentations, different state constitutions have different requirements for what the map should look like. One of the requirements in Wisconsin's constitution is that the districts have to be contiguous. Right? We all took geometry at some point, right? All the land has to touch. That's not contiguous. You see those little white islands? Those are not lakes. People live there. And you've seen, a few of these. There was one, right? Here's another one, right? We're up by Green Bay. People live here and people live here. And that means that the folks who live here, if they want to talk to their representative, they've got to drive or walk or bike or snowmobile across this part to get over there. That's not what the Constitution says. And I don't want to talk too much about the legislative proposal that came up suddenly and unexpectedly last week in Wisconsin. But and Michael said he's not sure it's really an effort at reform. I think that's a fair statement. I'm happy to answer questions about it. But one thing I will note about that proposal is it does something that I'm pretty sure you can't do. It says, we're going to enact into the statutes a provision that says when the Constitution says the maps have to be contiguous, it means they're allowed to be non-contiguous. I don't think the legislature gets to use a statute to just say that the Constitution means the exact opposite of what the people who wrote into it. The legislature can try to change the Constitution, no doubt, right? But there's a process for that, and it's not just passing a law that says up equals down. So here are just 3 more examples of non-contiguity around the state. A number of people since we filed this lawsuit have said, this is ticky-tack, this contiguity thing, it's not a big deal. And show me an example of a district. So of course I bring them these examples. You've seen 5, but it's actually easier to find an example of a district that is contiguous. Of our 99 assembly districts, 55 of them have this problem. This is not a little isolated thing. Now, I don't do this often, but let me say something in fairness to the legislature. How did it get like this? Well, let's use this one. This is Madison. This is the Madison area. Oh, nope, that one's Eau Claire. Sorry. So here we are. We're near Madison. A lot of these, they're following municipal boundaries. So for reasons that we don't need to get into, these little islands, they're actually like part of municipalities that are outside of that district or something. Wisconsin allows that. Wisconsin municipalities, for various reasons involving taxation and government services and all kinds of things you don't want to know about, have chosen to do that, but that doesn't mean the districts can be non-contiguous. What's happened since we filed this case on August 2nd? A second case, a sort of a companion case, was filed by others on August 4th. The court required responses from the defendants saying, do you think we should take this case or not? Those responses have come in. As part of those responses, some Republican senators and the legislature institutionally asked our most recently elected Supreme Court Justice, Janet Protasiewicz, to recuse herself from the case. And there's been a whole bunch of briefing on recusal. The most recent briefs went in on Monday, and that, I believe, at least for now, will be the end of the briefing. And so there are a whole bunch of things that are still to come, right? We're expecting a decision from Justice Protasewicz on whether she's going to hear the case. We're expecting a decision on whether the court's going to accept these petitions. We're expecting a decision on whether the legislature gets to participate in the case. And then, these cases could be merged together, and there could be real litigation. So with that, I just wanted to give you a brief snapshot of what's happening in Wisconsin, sort of as an example of what's happening around the country. And I'm going to stop, and we'll move on to questions.
Yeah, before we get to your questions, we're going to rearrange the deck chairs here so we can get them in front of you.
I don't know where the chairs need to go, but I will.
Here, that's okay. We'll get you.
Hi, all. Jack Kelly from Wisconsin Watch, formerly of the Cap Times. Jeff, good to see you. Question for you, Jeff. Are you satisfied with the pace of the case so far? Obviously, the briefing schedule, there was a big to-do about the fact that it took 3 days last time. It took almost 2 weeks this time, and for the reply brief from WAC, et cetera, et cetera. What are your thoughts on the pace of the case so far?
I guess what I'd say is that we've been very clear from the beginning. Every day that the partisan gerrymander remains is an affront to every voter in the state of Wisconsin. And this needs to be done in time for us to have fair maps for the 2024 election. You all have a deeper understanding of the mechanics of democracy than the average voter. When I say to most people that this needs to be done in time for the 2024 election, they're like, great, you've got a year. To get on the ballot, so to be on the ballot for the November 2024 election, you got to win the August 2024 primary. To get on the ballot, the ballots, because there are congressional and federal elections on that map, those ballots have to go in the mail 47 days before the election, which means they got to go in the mail in June, which means they got to be printed by the end of May. You got to go to the Wisconsin Elections Commission with your signatures to show that you qualified for the ballot. Those signatures start getting circulated in April. You can't decide if you're going to run for office and start collecting your signatures, which can only be from people in your district, until you know where the lines are. So the Elections Commission has told the court, for the maps to be used for the 2024 election, they got to be done by March 17th. I would say there's a little play in the joints. Last year, the maps were handed down on April 15th. We made it work. April 1st would probably be fine. But so to me, the question isn't the pace of the case, it's can we meet that deadline? We filed a proposed scheduling order when we did this that would have had most of the merits, the case long ago accepted and most of the merits briefing done right now. I would prefer that. But we are not yet in a point where I think the court can't get this done, and so on.
Sure. I will just say, this is a very common thing for state defendants to try to run out the clock, right? I mean, if the case can't be resolved in time and there's no judgment, even if there is a judgment and you don't have enough time to redraw the map, you get to use that illegal map for the election. And so going slow is a state strategy. They will find every reason, and you see this in all the cases I've mentioned. The states are all trying to extend the briefing schedule. They will file appeals to the U.S. Supreme Court. They will do whatever because they want to slow go it and get a free election out of it.
I wanted to follow up. Robin Voss threw a curveball last week with the Iowa-style redistricting proposal. How close to the Iowa style was it actually is up for debate, I think. Democrats said it was disingenuous, didn't engage, didn't really try to offer substantive amendments to the bill, though they did, get the bipartisan, the not defined bipartisan condition added to it. Do you think that it is really imperative, regardless if Wisconsin ever moved towards a nonpartisan redistricting process, to have the state Supreme Court weigh in on whether partisan gerrymandering violates the state constitution, and if we don't ever move towards that model of nonpartisan redistricting, don't Wisconsinites just remain one election away from partisan gerrymandering once again being constitutional or unconstitutional?
Oh, I think until we get clarity from the Supreme Court, it's always a risk. And even if the legislature passes, even if this proposal becomes law, it's not clear to me it does a whole lot. It would be enshrined in statute rather than in the state constitution. The legislature could at any point amend that statute. The legislature could at any point suspend that statute and say we're adopting new maps, and the first sentence of the bill could be, for these purposes, we suspend the operation of this particular mechanism or process that we've put in place. So, my own personal view is it's very difficult to design a workable process when you don't know what the ground rules are. Whether you're raising kids, whether you're dealing with your friends or your roommate, right? You need to know what the boundaries are, and then we work from there. So I think it would be extremely helpful for the Supreme Court to tell us what the Wisconsin Constitution tells us about gerrymandering and about redistricting. And then within that, it is absolutely my hope, and I imagine the hope of most people in Wisconsin, that the legislature will find ways to draw maps. I don't think anybody thinks that the courts are best equipped to do this. But what we have right now isn't working. The only time since 1961 that the maps have been drawn through the legislative process in Wisconsin and not through a court was in 2011, when we had unified control and the red map process, and Wisconsin wound up with the most extreme gerrymander in the country.
Sorry, one final thing. How critical do you think Protasewicz's participation in the case? If she recuses herself, do you think that greatly hinders the case's chances of success? Whether it's the 6 justices versus the 7 of them. Are you more confident that the case would succeed before the 7 of them, or if she recuses herself, do you think you could still be successful?
I think congruity is a simple mathematical fact, and I think that I have every confidence that the court would fairly hear that. But there's a reason that our courts have odd numbers of justices, and that is to avoid deadlocks. And so I think that it is the rare instance in which we step away from that. As Justice Alito wrote a couple of weeks ago, recusal is up to individual justices based on the law that applies to their courts. We've fully briefed why we think recusal is not necessary here. And as Justice Alito said, when a justice does not need to recuse, when it's not crystal clear under the law, they have a duty to the people to sit and hear a case.
Hi, I'm Raga Justin. I'm a reporter with the Times-Union in Albany, New York, which is, as Michael pointed out, going through its own sort of back and forth with congressional redistricting, which I have to confess I don't fully understand. So my question is kind of maybe basic, but you had mentioned that there's lawyers and legislative counsel that have been stepping into this redistricting fight. Is that, I guess, in Wisconsin? And I was curious to know about the governor's stake here, the executive branch's role in not just here in Wisconsin, but also across the board, across the country, and particularly in New York, because I haven't heard in any of the articles that I've read, Hochul, our governor, hasn't necessarily been invoked. Her opinion on it, her office's opinion on it, and whether they do have any sort of power or authority in that. So I just am curious to know what, the executive branch's role here.
Generally, the role of a governor is, the redistricting plans pass like any piece of legislation, and in most states, there are a handful where the governor does not have a veto, but in most states, the governor has a veto. And how hard it is to override that veto depends on the state. In Kentucky, it's a simple majority to override a veto. In other states, it's 2/3. And so that's generally what the governor's role is. When these suits get filed, they're typically filed against the Secretary of State or the chief election officer, because what you're doing is you're asking for an injunction saying, you, person in charge of the election, you cannot use this map for the election. So even though this person knows nothing about the map, it had nothing to do with it, they're the ones who are sued just from the standpoint of, they're the person who you're trying to restrain. Typically, it is not uncommon for, if lawmakers are not sued, it's not uncommon for them to intervene to defend the map. And so that oftentimes happens. Jeff can speak more to the particulars of Wisconsin, but it's typically the case that there are legislative defendants in there, and it's typically a fight between, at the end of the day, really a fight between the legislators and the people bringing the lawsuit.
Yeah, here in Wisconsin, in the impasse litigation, the governor did intervene in that case and have lawyers who represented his interests. Here, the governor has, at least to date, not sought to intervene in these cases, but might. Let me quickly say the legislature institutionally has sought to intervene. And I mentioned earlier that there were some Republican senators. There are also some Democratic senators, and let me just briefly explain why. Like many states, we elect our entire assembly, right, our entire lower house every 2 years. But our state senate is on staggered terms. And so we only elect half of the state senate each 2 years because they're on a 4-year cycle, right? So we believe that the gerrymander is so extreme and has distorted Wisconsin so badly that if we can get new maps for 2024, we have to reelect everybody. And so the 17 members of the Senate who theoretically should not be on the 2024 ballot, we sued them individually and asked the court to issue a special order. In Latin, it's called a writ of quo warranto, that says you do not have the authority, you do not have proper title to the office, the public office you hold, and to force those people to be on the 2024 ballot so that the legislature would finally, for the first time in about 15 years, be constituted on actually for the first time in much longer, but that's a different story, be constituted on the basis of fair maps. And so that's why there are some senators who are, 17 of them, 5 Democrats, 12 Republicans, who are individually in the case. We didn't choose those people. Those are just the 17 people who are up in 2026. And then the legislature institutionally has chosen to come into the case.
Hello, my name is JC Whittington with Politico, based in Washington, D.C. For Michael, so the graph that you showed us on the where congressional maps may change before the 2024 election, the 10 states, I noticed that in the 3 you pointed out where there was a redistricting battle over districts that were majority black or almost majority black.
Right.
Wondering why, I mean, and this is something that we hear about pretty often when it comes to redistricting conversations, why black voters seem to be at the center of these conversations often, and are there any other minority groups who are sort of going through this cycle?
Well, I'll answer in 2 parts. One is, they're the center of these VRA suits that are brought by black voters seeking creation of additional black plurality or black majority districts. And that is really because, in places like Alabama or Louisiana, the voting patterns are so racially polarized that, unless it's very easy to dilute black political influence, right? If you draw a district a little bit differently, black voters, black voters don't have many allies who will vote with them, right? And that's different in other parts of the country, like in Washington State, or even in Wake County in North Carolina, you can have black representatives elected because there's a lot of crossover votings. There's multiracial coalitions, but that's not the case in a state like Alabama, which doesn't have a lot of people who aren't black or white, and white voters overwhelmingly vote Republican, and black voters overwhelmingly vote Democratic. The other thing I will say is that the reason why I think black voters oftentimes feature in this story is that it's really very hard, whether you're trying to discriminate on the basis of race or politics, to not discriminate against people of color, in particular black people. And the reason for that is, if I'm trying to do a partisan gerrymander, what I want to do is I want to either break up my political opponents or I want to pack them all into a district, right? And that's sort of how you do a partisan gerrymander. Those are the 2 tools. It's very hard sometimes. There are certainly white Democrats, right? But the problem with white Democrats is that they tend to live near white Republicans, right? Sometimes in the same houses. And it's very hard to draw lines just to cut down the side of the bed and do all of that and get, and to do your gerrymander. Because of residential segregation, it's much easier to say, oh, we'll just split this black neighborhood and that'll split a big pocket of Democrats, or we'll combine all these black neighborhoods together, and even though they're far flung, and we'll put them all in the same district because we know that those are overwhelmingly Democrats, right? And so it's very easy, whether you're doing a partisan gerrymander or a racial gerrymander, to have a racial impact. And that's especially the case with black voters, because black voters are so heavily Democratic. Like Latino voters in Texas, for example, sometimes vote 40% Republican, 60% Democratic. You're if you split a Latino neighborhood, you're getting a lot of Republicans as well as Democrats, and the same thing for Asians. But black voters, it's like a big block of 90%. And the similar tool, if I were a Democrat trying to gerrymander, the same trick I would do is to split white rural areas, which are so the equivalent of black neighborhoods, and so it's just they're big pockets of people who have a partisanship that I can split. So.
My question is kind of similar, actually. So I'm Jad. I work for VPM News in Virginia. So I don't know if you followed the saga of the Virginia Redistricting Commission, which was a big bust. But one of the things that they were
hard to explain to people.
What's that?
It's hard to explain to people, oh, here's the process.
Yeah. one of the things that was discussed in that redistricting commission was the idea of coalition districts. So like it kind of touches on what you're talking about. So there were counsels for the lawyers for the Republicans and the Democrats, and they disagreed whether a coalition district would sort of hold up under the Voting Rights Act. So I was curious to get your thoughts on that, and if you could maybe summarize the arguments for why it could or couldn't, because I think it's going to be more important.
Yeah. So what you mean by a coalition district, just to put that in context, it is a district where it might not be majority black, but it might be majority black and Latino, right? And the question is whether you get to count black voters and Latino voters as a group for purposes of meeting the 50% plus one threshold that you have to show to get liability under the Voting Rights Act, right? You don't win a Voting Rights Act case under Section 2 unless you can draw a district that's majority minority. The question is, what is the minority? And a lot of circuit courts have held that you can, if the groups are politically cohesive and there's sort of an argument that you can count them together. The Sixth Circuit, which includes Ohio and Michigan, has said you cannot. The Supreme Court has never weighed in on that issue, and at some point the Supreme Court is likely to weigh in on that issue. I think the argument that people on the other side would make is like, oh, well, that's not actually an ethnic community. Like black and Latino and Asian voters or whatever groups you're combining aren't actually a ethnic community. That's just a political community, a Democratic community, and all you're doing is trying to draw a Democratic district and lock in a Democratic district, and that's just politics, and the Voting Rights Act doesn't protect politics, it protects discrimination against racial minorities. And that's the argument, and we'll see how a much more conservative Supreme Court handles that issue. So
We're getting close on time, but I'm wondering if you all are willing to stay a little longer?
A little longer, yeah, sure.
Okay.
Hi, I'm Sarah. I am a reporter in Vermont, which is a single-member U.S. House district, so that congressional districting is a little moot for me at this point. But the big battle actually in Vermont this past redistricting time for legislative districts was single-member versus multi-member districts. In fact, the last election cycle, it was so extreme that the most populous county in Vermont, Chittenden County, which is home to Burlington, the biggest city, had 6 state senators. And so foreseeably, if you lived in Burlington, you had 6 members of the Senate, which is a 30-member body that you could call and, opine about a single issue and whatnot. I'm just really interested what you, Wendy, I know you can't really opine on these sorts of things.
This particular one I might.
Okay, awesome. I'm really interested what you think of that, like in terms of equity, and if this is that's a fair way to draw a legislative map.
Well, let me just start by saying that over the course of history, we've moved from many multi-member districts to few multi-member districts. And the second piece is that many of the remaining states, and I don't know, it's about 6 or 8 states right now that have multi-member districts, many of them are, here's a Senate district, and we're going to nest 2 House districts within it. So the geography is all one, and then you draw a line. So Maryland and New Hampshire and Vermont and maybe West Virginia come to my mind. And West Virginia, I believe, went away from it a couple, 3 years ago, and now you've got Vermont. So the trend is very clear towards single-person districts. Now, in Congress, there's a whole other thing about multi-member districts, which I don't think I can explain, but the concept would be if you went down this path for Congress, you'd have some districts that would have 8 members in Manhattan, and 7 would end up being Democrats and 1 would be a Republican. So then if you were a Republican in Manhattan, you'd know who to call. But if you're a Democrat, you got 7 people to call, and that's really hard. Who's going to listen to you? So I'll stop there just with basically the trend.
I think there's a lot of conversation around multi-member districts. I mean, I think part of the problem with multi-member districts, it's like how you determine who the winner is, right? Is it like you have 6 people, but it's all like everybody, like you vote for the Democrat, every Democrat gets like 51% of the vote, right? So they win all of them, right? Is it sort of like basically an at-large election in a multi-member district? Or do you use some form of proportional representation to say like, oh, well, Republicans got 49% of the votes in this 6-person multi-member district, so they get 3 of the seats, right? So there's a difference of how you allocate it. And I do think that there's a lot of interesting conversation about could we use multi-member districts for Congress. Right now it's not allowed. Since 1842, Congress has said you have to have single-member districts. but it might be a more flexible way of letting people define what their communities are, right? Because in places like, I'll just give you one example, like in New York, there was a question of whether you would break up Sunset Park, which is in Brooklyn, which is on one side Latino, on one side Chinese, and many people in the community said, no, we're a functioning community. Like, we may be different ethnic groups, we function together and we work together on issues, and it's important for us to remain together. But other people said, no, you're Latino, you should go in a Latino district, right, with people who are kind of far flung. And the question is, maybe a multi-member district would let people decide themselves, like every election, like, hey, my Latino interests are actually really important, there's some things I'm going to vote with these other Latinos on another part of the district, or you vote your Sunset Park interest, right? It's sort of like letting people, and I think that sort of may be important in a world where, 30% of the country will be Latino or Asian by 2030, right? It's a very different country. 4% were Asian or Latino in 1965 when the Immigration Act passed, right? And so, letting people sort of sort out who they are politically in a flexible way might be a good thing, but we have to look at how multi-member districts perform. I think one of the concerns for multi-member districts is racial and ethnic minorities tend to turn out at lower rates. So even though Latinos might be 35 or 40% of a district, and in theory, could win one of the seats in a multi-member district or several of the seats in a multi-member district, their turnout might be so low and white turnout might be so high that white voters win all of the districts. And so you have to think about the design matters, I think, but I think it's going to be a conversation that we have, in part because, it's getting harder to win Voting Rights Act cases, and congressional districts are already so large. It's kind of hard to make that work. So.
Hi, I'm Haley. I'm a reporter with the USA Today Network in Ohio. So things have been going very well in our state on this front lately.
I feel like everyone says that. Everyone says, my state is so.
This is kind of a political question. So something we hear a lot from Democrats in Ohio, as there's this ongoing debate about whether Ohio is still a bellwether or whether it's a red state now. Republicans consistently win statewide office, or at least they have in the past few elections. Democrats say the gerrymandering of our districts has suppressed voters' interest in participating. Is there data to suggest that gerrymandered maps reduce voter participation or voter interest, contribute to voter apathy, or is that just our Democrats trying to clamor for relevance?
Well, I definitely think it increases cynicism, and that impacts turnout. We are doing some work on that right now to try to see if there's something objective that you can say about that. But just anecdotally, when I did political work in Texas, you would call up people and say hey, can you vote for Jeff? And people would say well, why should I vote? They've already determined who's going to win. And it's well, you should still vote, right? But it's people. It does sort of make people kind of cynical, and it doesn't sort of incentivize people to sort of turn out voters, right? I mean, running campaigns sort of requires money and engagement, and who, if you're, if this area isn't competitive, that money doesn't flow in. And I think, one of the prime examples of that is, in Texas, and up until, Texas in the early 2000s, they did this infamous mid-decade redistricting that redrew a bunch of Democratic districts to be Republican districts. Once Republicans took control of the legislature, these were congressional districts. And once you had Democrats no longer be competitive in East Texas and West Texas, what happened is that all the, when the districts were competitive, all this national money flowed in. So it went to the local parties, and it was turn out the vote, take people to the polls, rent buses, do all of that stuff. And so you had a lot of Democratic local elected officials, from county commissioners to sheriffs and the like. Once that national money stopped flowing in for the congressional races, because the congressional races were no longer competitive, the local parties died on a vine, and very quickly you saw Democrats who, at the county commission level, the sheriff, the county judge, lose, or they switched parties, right? And so now East Texas is very Republican, but that's in part because you lost the money that sort of like kept things going.
There's a real pipeline problem too. When the state legislature is heavily gerrymandered, it's harder to recruit candidates to run for districts that aren't competitive or serious. But that also means if there are fewer Democrats, or in some states like Illinois, fewer Republicans in the state legislature, there are fewer staff positions for young people who'd like to learn sort of the art of politics and care about policy. They're going to leave. They're going to go somewhere else. They're going to find something else to do. And then 10 years later, you've got people running the party looking around and saying, why can't I find any candidates? Why isn't there anybody good in that part of the state who's willing to run? Well, you've dried it up from the beginning, and everything's withered on the vine. So it has to do with local elections and local positions, but it also has to do with the way the legislature works. And you lose any representation in a meaningful sense in the legislature, you're not going to get good staff people. You're not going to get that kind of creativity. I would also suggest that good policy comes out of these debates. There's a reason that across time we designed a two-party system. And when you dull those debates through gerrymandering, you get less good policy because what do the proverbs say? Iron sharpens iron.
Yeah. And it also, I do think it increases polarization. Just, the only thing that matters is the primary, and polarized politics tends to turn off a certain segment of voters. So.
Which all of this feeds into how do you fix it? There are plenty of people who have told me that they think that we've had 12 years of an extreme partisan Republican gerrymander in Wisconsin, and so the solution is that the court should impose 12 years of an equally extreme pro-democratic gerrymander. Well, this strikes me as profoundly misguided because it's fundamentally anti-democratic. It feeds into cynicism. Why should people vote? And how are we going to get good policy? That said, there is a real problem if our system incentivizes partisans always to push the envelope and be as extreme as they can, because the worst thing that happens is it takes a long time, as Michael talked about, and a court's going to slap you on the wrist and put you back to where you should have started. Where are the disincentives? Where are the deterrents to stop people from doing this? And so, there are a lot of interesting questions beyond just what are the guardrails, what does the Constitution say? We got to figure out how to deal with this, but we need to find a way to deal with it that doesn't make things worse.
A lot of states have gone to commissions to look at this issue. Can you discuss the utility of that, or are they merely an arm of the partisan wielding the heaviest hammer?
I think a well-designed commission along the lines of California or Michigan is miles away better. And people will sometimes nitpick at commissions and say these maps aren't perfect for this reason or that reason. But in states like Michigan, you go from maps that are highly biased, that really rate an F, to maps that you can quibble about whether it's a B, B plus, A minus. That's a huge difference. Like if you had a kid who was making Fs and got a B, you'd be really happy, right? And an A minus, right? It would be even better. But and the thing is, you see litigation in these states, it doesn't take years to resolve. California, every time California's passed maps, I think this time unanimously, right? Last time almost unanimously with Democrats, Republicans, and independents. And that's the key thing about commissions is a well-designed commission includes independents and third-party supporters. It just makes it a better process. Now, it has to be well-designed. There are cases like Virginia where it's really, I don't know what you even call it. It's kind of a Franken commission. New York had sort of a similar system that was sort of really complicated. But if you take politicians out of the mix and you design it well, and I go around the country and I talk to people about, and when you talk to lawmakers, they're all like, well, isn't everybody partisan? And it turns out no, it's actually some of you are really partisan, but the average person can sit on a jury and say I don't agree with Jeff, but this seems fair or unfair, and let's work this out, right? And it's a great model. They almost all come through ballot initiatives, which is really, let me put that too high. Really hard to do generally, but impossible in a number of states, including Wisconsin. Where
right, Wisconsin doesn't have ballot initiatives.
Where you would think you would have ballot initiatives, but somehow they left that out of the progressive era reforms.
Right.
I was going to piggyback off that, actually. I'm from California, LA Times, and we did pass, the commission did pass the maps unanimously, the 14-member panel. It's 5 Republicans, 5 Democrats, and 4 no party preference voters. So I was going to ask for your opinions on how independent commissions have worked so far, and if there are any shortcomings, specifically California or Michigan. But one of the first stories I ever wrote for the Times was how a commissioner was missing so many meetings. He was filming a reality TV show at the same time as being on the commission. Like, there was another man who got a new job and like stopped showing up to meetings.
Yeah.
So they're not without fault. Maybe that was a product of COVID and the meetings being online. People would like log in, get their, maybe this is a cynical journalist in me, but they would log in, get their per diem, right? And then turn the camera off for like 7 hours.
Yeah.
And then you had on the other side, like really engaged, high quality, like incredibly just passionate people who wanted to draw those fair maps. So I guess like, it's really easy to write a story about how like the Wisconsin State House is gerrymandered and lawmakers are gerrymandering these maps. But it's a little bit difficult to say this independent commissioner or this independent commission, like the accountability there. So
Yeah.
I'm really curious to hear your thoughts
Well,
on all that.
I do think, the first time around in 2011, the California Commission, like they didn't do virtual meetings because nobody could do virtual meetings at the time, and they literally traveled around the state together. They would carpool together, and like they would have dinner after every meeting together. And the rule was you could not talk about commission business, right? They really developed bonds just as people, and I think that helped a lot. And they. But you're right. I mean, the commission selection process has to be really careful. I think sometimes a challenge for commissions is making sure, especially in a state like California, that you have the requisite diversity. Like California is so diverse. I mean, it's not just that it has Latinos and Asians, it has like 12 different groups of Asians and like 15 groups of Latinos, right? And like they don't always see eye to eye, and LA is very different than San Francisco in the Bay Area, and the East Bay is different than like San Francisco, where you want to make sure in a 14-member body that you have the requisite diversity, and at the same time the sophistication to understand really complicated issues like how you comply with the Voting Rights Act, right? And we talk about Iowa, and people always talk about the Iowa model. Like Ed Cook from Iowa says, like Iowa's like really easy, right? Like it's not, there are no Voting Rights Act issues in Iowa, right? People tell the joke like in Iowa we used to have ethnic tension, but then the Norwegians and the Germans learned to get along, right? And it just is. It's a different kind of place than like California, right? And so I think you have to, and I think every time that people do a new commission, they learn from what happened before, and I think like you can kind of constantly tweak it, but it is so much a better process than what you saw happen with like the Los Angeles City Council, right? Which is like, that was a totally like, where again, you have politicians involved and they're sort of like prioritizing political interest and things like that. And so, is it a perfect model? No, but I think it is generally a better model. And, I think, California was like a big test. I think before that people thought, okay, you have commissions in like Montana, which is like Idaho, right? But that's
we have
not California.
a Montanan in the audience, just to be clear.
And not to bash any states, but California is like LA itself is so complicated just by itself. Like I think they spent weeks just trying to draw LA the first time around. I don't know this time around, but like it was just took forever to draw LA. So I think commissions are better, but they're not. I do think that sometimes the last thing I'll say is I do think sometimes I struggle in a diverse state, how to mediate between the claims when they're not claims like of a minority group against the white majority, right? Like when it's claims of Latino voters that would impact representation for Black voters, right? And how do you sort of like try to like not make it a zero-sum game? You win, I lose, right? And that's sometimes hard to do, and it's sometimes very emotional. But the best way to do it is, I think, to get lots of information. And in California, I always point to the wildfire district that they drew in the foothills, right, where they kept the foothills together because people said, we're in different districts now. That makes sense. Those districts aren't illogical, but we'd like to be in the same district because no one is paying attention to wildfires. And lo and behold, the commission said, like, that seems like a really good reason. They put everybody in the same district. And that if you go to that representative's website today, she talks about all the work she's doing on wildfires. Everybody campaigns on wildfires in that district, and that's better representation. And that's not what people would have thought when they designed the commission, but it's what a commission can do. I doubt that lawmakers ever would have done that.
We probably have time for one more.
Clara Hendrickson, Detroit Free Press. Just curious, what is your definition of political fairness?
My story about that is always that nobody's got a definition of it. And you used the word fairness earlier, and I thought, oh, I wonder what measure that is. So I will just let that go.
Yeah, I mean, I guess what I would say is, Michael was talking about rating maps. There are no perfect maps. And one of the reasons I keep saying partisan gerrymandering, you can look at any map, no matter how carefully it's drawn, and you can characterize it as a gerrymander somehow. Right? It is racially unequal. It is unequal income-wise. There's so much data. I think that we need to be looking for maps that meet the law and that create competitive races in places that are competitive. Now, there are going to be places that aren't going to be competitive. I get that, right? I live in Madison. I live a couple miles from here. I can tell you when I look at the election results on poll night, if there are about 1,000 people in my ward, my friends and I can play the let's name the 8 people who voted Republican game in our neighborhood, right? Like, I get that. So we're always going. There is some truth to the geographic sorting, but we should be looking for maps that overall keep our states, make interesting competitive races, and keep our states so that everybody has a fair chance and are roughly, I'm not talking about pure proportional representation or anything like that, but within the other constraints that we have geographically, I think it would be good if our elections were within shouting distance of the proportions of how people are voting.
And I will say, I think what you're looking for is outliers, right? I mean, as what you're hearing from everybody is there's a broad range. There's thousands of maps that could comply with the requirements of law, and which one is best. It's sort of like the business judgment rule, right? It's sort of like, it's a reasonable choice from the range of thousands of reasonable choices. But there also are outliers where, you don't get there unless you're putting your thumb on the scale. So North Carolina is a prime example. It's a 50-50 state. Democrats win statewide, Republicans win statewide. The Republican map that was drawn last decade had 10 Republicans and 3 Democrats, right? You don't, North Carolina is a battleground state. It's not a 10-3 map, right? And that's sort of so you can spot the outliers. So I always tell people it's a little bit like, what do I wear to the beach? Well, there are lots of things you could wear to the beach. You could wear shorts, you could wear canvas pants, you could wear a light jacket, you could wear a sleeveless shirt. If that's your thing, you can wear a hat. But you shouldn't wear a parka, right? And there's what you're trying to do is prevent the outliers, within the box of reasonable choices. Let the politics sort of play itself out. But if you go beyond that, and it's really, if you think about it from the standpoint of spotting outliers, it's really not hard to spot something that is so extreme. And with computational power, you can run millions of simulated maps and say whoa, you don't really get here, except you never get this kind of outcome ever. We ran 3 million maps, and you never get this outcome ever. And that seems to be a problem, right? So.
And that's what they did in the litigation in Wisconsin over the 2011 maps that went up to the U.S. Supreme Court in Whitford. They ran, tens of thousands of maps that met all the legal requirements, and then they ran the election results through those maps. And of all of those, nearly 100,000 maps, the existing map that the legislature passed was the 3rd most partisan. Right? That's an extreme outlier, and that's why a 3-judge panel with 2 judges who were appointed by Republican presidents said that the map was unconstitutional.
Well, I'll end it here, but Wendy started the conversation by saying that this was the time for us to eat our vegetables, and I think the 3 of you made vegetables taste very, very good today. And I want to thank you very much. Thank you for all of your questions, and appreciate very much you all being here today.
Yeah.